Every day in the USA, people find themselves in court.
State of Kansas versus Anthony Edward Shelton. It's case number 2025 CR15. Amber Norris appears for the state of Kansas. James Watts is defense counsel. Defendant Shelton appears at a court security monitored Zoom location at the Butler County Judicial Center. This matter comes before the court at this time for sentencing. The court's docket notes indicate that the defendant appeared before this court on January 15 of 2026. At that time, he entered guilty pleas to amended count 1, a level 4 possession of methamphetamine with the intent to distribute, count 2, felony theft, a level 9 felony, and count 3, class A misdemeanor theft. A pre-sentence report was ordered with sentencing set for today. Court has received a completed pre-sentence investigation report compiled by Tyler Winter, pre-sentence investigator. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in that report?
No objection, Your Honor.
Any from the defense, Mr. Watts?
Your Honor, I've reviewed same with my client. We believe it is correct, but have no objection.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Ms. Norris, are you aware of any legal reason why sentence should not be pronounced in the Shelton case here today?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir. Thank you.
Mr. Shelton, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing at this time?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
At this point, no, Your Honor, although I will tell the court what is characterized as the lead count in this case is confusing because it appears to be, on the one hand, presumptive prison and on the other hand, mandatory drug treatment. I would note that count 2 is also a mandatory drug treatment under Senate Bill 123. And I've been going through the desk reference manual to see if I can reconcile those two things. It appears he's going to be mandatory drug treatment under Senate Bill 123. And assuming the court does not disagree with that, then no, I don't anticipate any departure motions.
Mr. Watts, I'm not sure the proper question is whether the court agrees with it or not.
Yeah.
The question really is the court compelled to follow it? At this, I tried to reconcile, I think, all of the difficult things that were raised by this pre-sentence report, and I did have a discussion with Ms. Winter last week, even regarding what should be regarded as the primary offense in this case. However, at this point, the court is satisfied at this juncture that apparently what has been presented to the court is correct, unless counsel has some different argument they wish to make, and the court intends to proceed further accordingly.
Understood, Your Honor.
Very well. Thank you, Mr. Watts. I appreciate the discussion and the difficulty that I think we've all had in sorting out this particular case. Again, the court adopts the criminal history as stated in the report. We are proceeding as if that the primary crime is a level 9 grid box E on the primary count. Are there any victims or members of a victim's family who desires to address the court in relation to this sentencing? Court finding no such persons present. At this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Shelton, beginning with Amber Norris on behalf of the state of Kansas.
Your Honor, regarding count 2, the felony theft, would ask the court assign defendant to 10 months in the Department of Corrections. Defendant would be able to earn up to 20% good time credit and will be subject to 12 months post-release. Your Honor, it does appear there are two special rules that apply, which make this case presumptive prison. Basically, the prior thefts and the crime committed while on felony bond. But Your Honor, this is a mandatory SB 123. So we would ask the court assign defendant to up to 18 months community corrections probation with all standard and PSI recommended probation conditions. Defendant has earned 3 days of jail time credit. And regarding count 1, 15 months in the Department of Corrections. And regarding count 3, that is a misdemeanor theft, 12 months in the Butler County Jail. Your Honor, there is $400 in KBI lab fees to be assessed to the defendant, standard costs and fees of the action as well. SB 123 fees of $300. There is no request for restitution outside of the KBI. All standard and PSI recommended conditions, including obviously the drug alcohol treatment, employment. Defendant was notified at time of plea of his notice of duty to register. So we would ask the court remind him of same today. Court will need to address court-appointed attorney's fees as Mr. Watts is appointed. And Your Honor, we would ask that this case run consecutive to Sedgwick County District Court case 24 CR 1929. He was on bond in that case at the time of the commission of this offense. Otherwise, Your Honor, I don't think the state has any further recommendations for the court.
Very well, Ms. Norris. Mr. Watts, your recommendations regarding an appropriate sentence.
Your Honor, similar to Ms. Norris, would recommend on the primary count 2, the standard range of 10 months with the post-release good time credits, and probation duration is noted, as Ms. Norris noted, this is apparently a mandatory drug treatment program case as well. As to count 1, it's likewise, had that been a lead count, would also be a Senate Bill 123 case, although given the status of count 1, that's really redundant and not really applicable. We'd recommend the standard mid-range of 15 months at that point of that case, as well as on count 3, a 12-month on the A misdemeanor theft of property. Would ask those cases those sentences run concurrent with each other. Place them on probation with community corrections with the normal and usual conditions that go in a case such as this one. I have emphasized to my client the absolute necessity of fully participating and being very diligent in his probation and the Senate Bill 123 treatment programs. That's all I have, Your Honor. Thank you.
And your attorney fees and the representation of this client would be how much, Mr. Watts?
Judge, this was billed to bids or will be billed to bids at $13.20.
Thank you. At this time, the court will address the defendant, Anthony Shelton, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court.
Yes, Your Honor. I just want to say I was released from Lansing in December. We set this off a little bit, so kind of gave me a little bit of rope to see what I was going to do with it. But in that time, I've registered in, he was telling me I didn't have to, but I registered in Butler County, then registered in Sedgwick County. Right after that, I started treatment myself. I have a letter here from treatment for you. I'm instead of just doing the outpatient treatment on the group, I'm taking individual. So instead of 1 a week, I'm doing 2 a week. I'm doing an individual and a group counseling. I've never really had to do that before, so I think I need it. I think it's something I have to do. I don't know if this treatment would be considered for that. This is just something I had to get into before, as soon as possible. So I did. I've also got mental health stuff set up through my treatment to do. That's all part of this too. I'm doing good on parole. I've got a job. I've got a house. I've spent the last 3 months really trying to get on my feet and get things going. So far, I'm doing really well. I don't know. I have to make a change. I mean, I'm not a bad person. I'm not, I have a drug addiction that's pretty bad, and I wouldn't hurt anybody else. That's why I've got all these charges, but never had a person felony. I'm nonviolent completely, but I do have to change. I'm tired of going in and out, and there's other factors with family and stuff that's involved that it's that time. I can't do it anymore.
Anything else, Mr. Shelton?
I don't think so, no.
The court will pronounce sentence shortly, but I think some remarks are appropriate here. Quite frankly, Mr. Shelton has a shocking criminal history. 31 prior felonies, 46 prior misdemeanors. Quite frankly, Mr. Shelton, the court finds it incongruous with community interests or any interest or fair notion of justice that this court would be forced to place you into a community-based alternative under current Senate Bill 123-based drug treatment laws, which currently exists, which essentially compels, in this case, a community-based alternative. Mr. Shelton, you should be in prison on this, not in a community-based alternative. Recognizing that, the court will formally pronounce sentence at this time. The court hereby establishes count 2 as the base sentence in this case for the offense of felony theft, a severity level 9 non-drug, non-person felony, in which the defendant has a criminal history score of E, thus placing him in grid box 9E. The court hereby sentences the defendant to the aggravated term of 11 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. Regarding the additional offense in count 1, for the conviction of possession of drugs with the intent to distribute, a severity level 4 drug non-person felony, in which the defendant has a criminal history score of I, the court hereby sentences the defendant to a term of 16 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 24 months of post-release supervision. The court imposes no fine on that count. It is the intention of the court to run counts 2 and 1 consecutively with one another. The court is aware of the double rule, which applies here. The court essentially will enter an order of a 22-month prison sentence, which is twice the aggravated term as imposed on the primary count. So this is a 22-month DOC sentence in this case. With that announced, the court does find that based on the high probability of Mr. Shelton having a substance abuse disorder, as indicated by the SASE instrument in this case, further, that there's a high risk assessment score on the LSCMI, the court must recognize that this is a mandatory case for Senate Bill 123 community-based treatment under current statutory authority in the case. Again, with the court expressing all of its regrets earlier, ultimately, the court determines that mandatory does mean mandatory in this case, and that in the view of the court, an undeserving defendant is going to receive the benefit of this law for an initial community-based alternative in the case. Therefore, the court will grant the defendant up to 18 months probation duration to be supervised by community corrections as part of up to 18 months of drug treatment which is required by law in this case. Conditions of probation will include the defendant observing all laws, reporting to an officer as directed, submitting to and following through on recommendations made by a qualified substance abuse evaluation. He shall not possess or consume alcohol or illegal drugs while on probation. At his supervising officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to program requirements, gain and maintain employment successfully throughout his probationary term, notify his supervising officer of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place. He shall register as an offender, drug offender under the Kansas Offender Registration Act, abide by any curfew or travel restrictions imposed by his officer. He shall complete Senate Bill 123 treatment and follow all aftercare recommendations, not have in his possession firearms or dangerous weapons. He is not to associate with any disreputable characters or places, which Mr. Shelton means anywhere you could be offered drugs or get drugs. Community corrections is authorized to require the defendant to meaningfully participate in the MRT program. The court will assess $400 to the KBI laboratory, $193 felony docket fee, the community corrections fee, correctional supervision fee, $300 in total reimbursement to the Senate Bill 123 treatment program. However, given the current status of this matter, the court cannot determine that Mr. Shelton, recently released from DOC custody, has the financial resources to pay bids amounts, and the court will waive the application fee and bids attorney fees in this case. The court will require the defendant to pay at least $75 a month on these obligations. Furthermore, this court is empowered as a condition of probation to order up to 60 days in the Butler County Jail. This court has rarely seen a property crime or drug case that calls for incarceration more than this one does. Mr. Shelton, your track record is that you steal to get what you want. You've done it again here. It would not appear to this court, just looking at your overall criminal history and even the circumstances of this case, that it's drugs that's really the issue. The legislature would disagree based on the outcome of some assessments and testing that you've done, but you're a career criminal and you're a career thief. This court is going to order you to serve 60 days in the Butler County Jail as a condition of probation. I do note that you have 3 days prior credit, so the court will order you into custody at this time to serve 57 consecutive days without release privileges in the Butler County Jail before being released into your community corrections program. And I've already dealt with the issue of jail time credit. There does not appear to be any restitution to be paid to a victim in this case, so no such restitution order will be made outside the reimbursement to the KBI laboratory. Again, I want to remind the defendant of his continuing obligation to register as a drug offender under Kansas law. At some point in the future, Mr. Shelton, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. Before I address appeal rights, I want to make sure the record is clear. I've already imposed the felony sentence in this case, and that the 12 months that the court will impose on the misdemeanor count will run concurrently with the time imposed on the felony counts. That is a 12-month duration sentence on the misdemeanor. Addressing rights to appeal in this case, Mr. Shelton, you may have the right under certain circumstances under Kansas law to appeal a conviction to an appellate court having jurisdiction. And if you are unable to pay the cost of an appeal, you, the defendant, may request the court to appoint a lawyer to represent you on appeal and to direct that you be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you there's prohibitions against a convicted felon possessing a firearm, and if there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. All right. Ms. Norris, are you aware of any other sentencing-related matter which the court has not fully addressed?
Don't believe so, Your Honor. Thank you.
Mr. Watts, are you aware of anything further?
No, sir. Thank you.
Mr. Shelton, you have any questions about the court sentencing orders?
No, sir.
If indeed you are motivated this time to stay out of trouble and complete treatment, I wish you success in that regard. I think you can even tell from the court's remarks today that you are an extremely fortunate individual, that you happen to fall into a category under the law that kept you out of prison, despite the fact that there were two special rules here which indicated that you were essentially going to be in prison. The Senate Bill 123 law apparently trumps those, and the court has ruled accordingly. I will note for the record that I think whether it would be a matter of discretion or not, or whether it would be mandatory under the law, any time imposed here would run consecutively to Sedgwick County case 24 CR 1929. I did want to announce that for the record. I will order at this time Mr. Shelton into the custody of the representatives of the Butler County Sheriff's Office until his custody can be transferred to the jail to serve the remaining balance of the 60 days imposed, which according to the court would be 57 days due to the 3 days prior jail time credit. Ms. Ashenfelter, she's a representative here from Community Corrections. What direction would you give Mr. Shelton at this time?
Your Honor, if we can do a brief breakout room, I can go over some requirements with him before he goes to jail.
Very well, Mr. Shelton. We're going to leave the Zoom meeting open after we recess court to allow you an opportunity to confer with Ms. Ashenfelter from Community Corrections. Follow whatever direction she gives under the circumstances.
Yes, Your Honor.
If there's nothing further then, the Shelton matter will currently be in recess at this time, and we can stop recording.
31 felonies and 46 more. Anthony Shelton's a career thief to the core. The judge is straight fuming, says you ought to be in jail, but Senate Bill 123 just kept him out of a cell. Oh, the Kansas loophole keeps him off the prison bus. Mandatory treatment, man, the judge is gonna cuss. Go do your 57 days in the Butler County suite. Then it's back to probation for the outlaw of the street. Yeah, 22-month sentence just hanging by a thread.